Good morning, members of the jury. Thank you. Everyone recalled. Good job. Juror number one, how did I do on the snugs?
Very good.
You're welcome. Before we get started this morning, I'm going to give you some preliminary instructions as to how the trial will take place and also an instruction on note-taking. Does everyone have a pen and notepad? If you can hold those up for me so I can see. For the record, each juror has a pen and notepad. After I've given you these two instructions, at that point, the parties will have their opportunities to give their opening statements, and the state will proceed with its case. Once again, throughout this trial process, I will be reading to you quite a bit. Again, it's not that I just do not wish to speak to you in a normal fashion, but the instruction that you are to receive from the court concerning the law during this case is to be specific, and it is to be uniform. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Donna Adelson. This is a criminal case. Donna Adelson is charged with first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. The definition of these offenses will be explained to you later in this trial. The state's charging document, which is called an indictment, is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Donna Adelson in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, the alternate jurors will be released, and you will then retire to consider your verdict in this matter. You should not form any definite or fixed opinions on the merits of this case until you have heard all the evidence, the argument of the lawyers, and the instruction on the law that I will provide to you. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify my courtroom personnel concerning the violation. During the course of the trial, the court may take recesses or breaks, and you will be permitted to separate and go about your affairs, or you'll be returned to the jury room. During these recesses or breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, please tell him or her that you are on the jury that is trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to my bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or electronic device is actually off and not in a silent or vibrating mode. You may use your devices during any recesses or breaks, but even then, you may not use your cell phones or electronic devices to find out any information about the case or to communicate with anyone about the case or the people that are involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess or break, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and they will be delivered to you without delay. A contact phone number will be provided to you for this very purpose. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This would include reading newspapers, watching television, using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places that are involved in this case. This instruction is going to apply to you whether you're in the courthouse, at home, or any other location until the trial has concluded. You must not visit places that are mentioned in the trial or use the internet to look at maps or pictures to see any place that is discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest of family members make comments to you or ask questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages that are related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure the information that you have obtained is actually proper and relevant to this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you may find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of the proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and all taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or potentially both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they believe are proper. When an objection is made, you must not speculate on the reason why it has been made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer that question. During the trial, it may be necessary for me to confer with the attorneys out of your hearing to discuss matters that require my consideration alone. It is impossible to predict when such a conference may be required or for how long such a conference may last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of this case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you choose not to. This is going to be an individual choice for each juror. You have been provided with a notepad and pen for your use if you do wish to take notes. Any notes that you take will be for your personal use. However, you are not to remove your notepads from the courtroom. During any recess or break, you are to leave your notepads in your seats. When the trial reconvenes, you will have access to your notepads once again. After you've completed your deliberations in this matter, my bailiff will deliver your notepads to me. From there, your notepads will be destroyed. No one will ever read your notes. If you choose to take notes during this trial, please do not get so involved in note-taking that you've become distracted from the actual proceedings. Your notes should only be used as an aid to your memory.